today's topic is, as you know, deepfakes and the future of evidence is a very, very hot button topic and something which is affecting everyone in terms of at least the AI, artificial intelligence, and all of the different ramifications of this technology, which is just racing at such a rapid pace. And especially when it comes to this subject, the deepfakes and the fabrication of imagery, the fabrication of sounds and voices. And I was very excited to be able to produce this webinar at such an interesting subject. And we have a really fantastic lineup of speakers, of presenters, and I'm going to give it to Justin to actually announce and to talk about who the speakers are. But in terms of Justin Danilewitz is now the second time that he's been the moderator for our webinar, and really shined so wonderfully in the last webinar that we did. I couldn't resist but having him back again for this one again. And Justin is the chair of the white collar and government enforcement practice at Saul Ewing LLP, a national law firm. He previously served as an assistant U.S. attorney in the District of New Jersey. He's been named to the best lawyers in America in criminal defense, white collar, and is recognized as a litigation star in Pennsylvania by Benchmark Litigation. Justin is also the co-host of the ABA's podcast, JustPod. So it's a very big pleasure to be able to introduce Justin in a minute, because I'd like to share the screen and play a short video as a segue and introduction into the webinar.
I am not Morgan Freeman. What you see is not real. Well, at least in contemporary terms, it is not. What if I were to tell you that I am not even a human being? Would you believe me? What is your perception of reality? Is it the ability to capture, process, and make sense of the information our senses receive? If you can see, hear, taste, or smell something, does that make it real? Or is it simply the ability to feel? I would like to welcome you to the era of synthetic reality. Now, what do you see?
Thank you so much, Rabbi Coleman. It's a real privilege to be back, and I'm honored to be re-invited to moderate another panel. I'm particularly honored to have such really tremendous people joining us today. And I think it's going to be a very timely and hopefully interesting discussion for the audience, again, on the topic of deepfakes and the future of evidence. Let me give our panelists a brief intro. They each have lengthy and very impressive bios, but in the interest of time, I'm going to abbreviate. Susan Lin is a noted and really highly regarded criminal defense lawyer and civil rights lawyer. She's a partner at the Philadelphia law firm of Carey's, Radofsky, Messing, Feinberg, and Lin, LLP. David Danilewitz is a national video and audio forensics expert and the founder of NCAVF, the National Center for Audio and Video Forensics, which has offices in both Los Angeles and Florida. And last but certainly not least, Rabbi Yitzchak Grossman is a noted Dayan, a rabbinical judge, who has served as a judge of Jewish law, halacha, in many rabbinical courts or batei din. He is the author of, among other things, Jewish Perspectives on Artificial Intelligence and Synthetic Biology, published in the Hakira Journal. Before we get underway, just very briefly, I want to acknowledge two of my colleagues, Min-Jae Kim and Celine Dugan, for their great research assistance, which I really appreciate. And with that, I think we can dive right in. Let me ask our audience to begin with to imagine a criminal trial involving a bank robbery. The video surveillance footage that the government prosecutor presents is clear and compelling. You've never stepped foot in the bank, but the video clearly shows you entering the bank, drawing a firearm, and handing the teller a note. It cannot possibly be true. And in fact, it isn't. It's a deep fake. If that sounds too far-fetched, consider a study that was performed where a number of study participants were actually asked to perform a certain gambling task. And then the researchers recording this altered the video to show the participants cheating. A number of those participants subsequently falsely confessed because they were so convinced by what they saw in the video. To flip the tables, imagine a sophisticated fraudster who makes calls soliciting investments, but does so using the distinct voice of someone else. Morgan Friedman, maybe not, but maybe the CEO or the CFO of the company. It sounds to the supply manager that the chief financial officer is asking for a transfer of funds and has taken the step of even confirming that by telephone to further authenticate the validity of the request. The supply manager recognizes the CFO's distinctive voice, but again, it's a deep fake. If that sounds too far-fetched, consider that in January of 2024, the British engineering firm Arup was victim to a $25 million deepfake fraud. An employee in one of the offices was on a video call with a number of senior management members and was asked to approve the authorization of about 15 transfers totaling $25.5 million, which the employee did. And then it was discovered that that video conference call was a deep fake. So there are almost endless examples of this phenomenon. The questions that are concerning us today are, how can the finder of fact, whether it's the judge or the jury, how can the finder of fact be supposed to identify the falsehood in expert quality fakes? How can we collectively, judges, lawyers, lay people, experts, avoid the introduction of inauthentic evidence? What basic due diligence should lawyers do before accepting the evidence their own clients present? What changes to our rules of evidence may be necessary to keep up with this evolving environment? And what insight can we glean from ancient principles of Jewish law spanning thousands of years about this very modern problem? So we've roughly divided up a short segment that's going to be delivered by each of our panelists. I'm going to turn to each of them in turn. Let me give you a heads up that at about 12:45 to 1, we invite people to take a break during that time if they'd like to. The panel will continue. We're not going to stop the panel. But I say that just to reassure people that if they step away during that time, we will not be announcing CLE codes, and that's for purposes of people taking a restroom break or what have you. Okay, so with that, let me begin with Susan. Susan, artificial intelligence can be good, bad, or neutral. I think it depends on who's holding the tool and for what purpose. But maybe you could start us off by talking just generally about the uses of AI in law, in litigation, for good or for ill. And first, I want to confirm that that's really you, Susan. Is that indeed the real Susan Lin?
Well, I am going to say that it is the real Susan Lin. Hopefully nobody has recorded me, and hopefully nobody knows my voice well enough and no machine knows my voice well enough to try and fake it, I hope. Thank you all for inviting me to join you all. This is the first of these seminars that I've been a part of, and I'm quite impressed that there is a group of people who are putting these on, and obviously many participants who are interested. I think I would like to sort of divide the world of AI usage in law into two segments. One is where the people who are using AI and presenting AI-generated product acknowledges that that's what they're doing. So, for example, an expert witness acknowledges that they used an AI tool as part of their analysis and used that in generating their opinion. Or a party who has introduced a video acknowledges that they used AI to try and sharpen or clarify the video. Or even a lawyer who is conducting research acknowledges that they used AI to at least help in the research that they did in writing the brief that they wrote. that's one category. And while that it has its own challenges as to how courts and judges should deal with that type of product, I think what we're more interested in in this seminar is the whole other category, which I would call the products that are made with AI that nobody acknowledges were made with AI. And this is the world of the deepfake. It could include briefs where lawyers, cite to fake cases and never acknowledge that they used AI to generate those fake cases. But we're going to talk, or I'm going to focus a little more about the photographs that may be completely fake, the videos that may be fake, the audio recordings that may be fake. And it's, as a lawyer, right, I wonder, am I now supposed to question absolutely everything that my client gives me? Am I now supposed to question absolutely everything that the opposing party gives me and tells me is a video of my client committing a bank robbery, for example? And if I'm going to question those things, what should I be asking for from my client or from the opposing party to sort of prove that what they've given to me is actually authentic? And we could talk about those things. We could talk about what judges are supposed to do and how they're supposed to react when one party accuses the other party of producing fake evidence. Is it one party has to prove it's fake, or is it the other party has to prove it's real? These are all sorts of the questions that I have in mind that we all need to ask ourselves if we are the lawyer, if we are the judge, if we are the client who is all of a sudden shown a video of them doing something that they never thought they had done. So that's how I approach this topic, is through those questions.
Fabulous. That's a really helpful starting point. I want to bring in David in just a minute, but before that, I want to just share a very brief anecdote. I remember, Susan, as a prosecutor in some of my earlier cases, getting the evidence that you've seen in a million different cases, where it's an audio recording, or your client has been unbeknownst to them recorded in some fashion. And I remember thinking, as a very young prosecutor, how am I going to prove that the voice on this recording is the voice of the defendant I'm prosecuting, right? I need to prove the case beyond reasonable doubt to the jury. What's the method to doing that? And I can recall vaguely at this point sort of discussing with the agents, what kind of technology do you guys use to prove that the voice on the recording is the voice of the defendant? And being surprised to hear back at the time, we don't use any such technology because the human ear is the best mechanism to identify a voice, right? So we've all heard Terry Gross on NPR 1,000 times. You can recognize Steve Inskeep on Morning Edition, Morgan Friedman, James Earl Jones, these wonderful voices that we're familiar with. But times have really changed significantly, and maybe that's a good place to bring in David, to ask you, David, who, in your capacity as a specialist handling audio and video technology and recordings, how do you verify, how do you authenticate this kind of evidence, or the opposite, how do you disprove, how do you demonstrate that it's inauthentic evidence? And maybe you could share with us some examples of where you've been able to do that.
Great. So thanks for having me. It's a great pleasure to be here. In terms of your audio situation, first of all, where you asked about fake voices, there are tools currently that you can compare between, let's say, the original that you know who it is, because we make recordings of people where there's doubt. We'll make new recordings of people. And then we'll compare those to the evidence that's been brought in to say, is this the same person? Is it really a completely different person? Is it maybe a voice that's been faked? And there are still tools that work. It's very hard, and the tools are constantly being improved. And eventually, I think it might be impossible for the tools to work. But as of right now, we get a lot of evidence from, let's say, a year ago or 2 years ago. And so the evidence was still, if it was faked, it was created by older tools, right? So, but nowadays, the tools have gotten incredible. I mean, just amazing videos, amazing audio. You can't even, I can't tell, So what happens there? Well, you have the basic tools that you always use in court, which is a chain of evidence. So in your case, with the bank, with the bank suggestion, well, where was this evidence gathered? When? Was it that day? So did the police go to the surveillance system and download it right then? If so, then it's a lot more trustworthy than, it showed up, 3 months later, and we don't know its source. So the chain of evidence becomes very important in that for all issues, whether it's video, audio, or documents, the same thing. We have to have notaries that say that they signed it and they have records of that. In the same way today, there's going to be video notaries in a way. It's going to be videos. So the second that a video is created, there's going to be tools that Sony embeds and Apple embeds and Android, all these different systems will embed in the signal, send them up to the cloud immediately so that we know the exact date and time and location of that original source video. We'll know in the audio or images, still images as well. And it'll have a unique number. So that kind of process is being developed right now. So I think that'll come into be huge in the next couple of years because they're building it into their technologies as best they can. And it's using technology to solve the problems created by technology, which is like a constant battle.
So just to piggyback off of what David was just talking about, prior to this world of deepfakes and all of us wondering if a video recording or an audio recording is authentic, in the example that Justin gave about how do you identify a voice, in many courtrooms during many trials, it was simply a matter of somebody getting on the witness stand, listening to the recording, and telling the jury or the judge, I know Speaker A, I'm friends with Speaker A, I have had many conversations with Speaker A, and I recognize that that voice is Speaker A's voice.
That's a very powerful thing because when you have the person who knows the individual is much better identifying a voice. And it's the same thing even with other races, people from, let's say, India or China or whatever, those accents, it should be recognized by the parents, by the nephew, by the friend, by someone who worked with them, for a long time. Like you said, Susan, it's exactly right. And that's how it's always been. And it will still be to some extent like that.
So judges now are even saying, given what they're asking for the information that David was just describing, they call it the metadata for any file. So for any video, it's not just what is shown and played, it is what is that background information that's connected to the file that the viewer can't see, but anybody, any computer forensic person would be able to see. Are judges now going to demand that all parties who are trying to introduce a video include the metadata to show that it is indeed an authentic video? And I see that Rabbi Grossman has a comment.
Yes. So I just wanted to add that in Jewish law, we've been grappling with this question for 1,500 years, from Talmudic times, well before recordings. We've been grappling with the question of voice recognition in legal context, simply in cases where witnesses, let's say, were behind a wall and they heard an incident, they heard a confession of indebtedness or something like that, and they simply didn't see the person. They didn't get facial recognition, and they had to testify to the court. We know it was so-and-so who admitted to confessed or to a crime or confessed to a civil obligation. We know. How do we know? Because we recognize his voice. This actually goes back to biblical incidents. In Genesis, there are two incidents involving people fooling each other by impersonation and questions about the voice. Jacob fools his father Isaac when he impersonates his brother and gets the blessings from him, and Leah impersonates her sister Rachel on her father Lavan's instigation. And from there, and from other Talmudic precedents, there's actually a rich literature we have spanning centuries about, do we consider voice recognition reliable? Again, no technology, no recordings, no metadata, simply a question of, do people who either know the person or don't know the person or have heard him speak at least once before, and all these things are discussed. But yes, obviously we have other opportunities today with metadata and so on, and chain of custody with recordings. But the basic question again goes back even earlier: how reliable is and also going back to your earlier point about, are we dealing with someone deliberately trying to mislead, or are we simply dealing with how reliable is an identification? Some authorities distinguish and say, if it's just a question of someone was behaving normally, we just want to know, is it that person? That's one thing. But if we suspect it was a deliberate attempt at impersonation, then even voice recognition is less reliable. And exactly the same questions go back well before the digital era.
Those biblical precedents are really interesting. It hadn't occurred to me, but that's really fascinating. Let me pivot slightly to ask Susan to address the capability of the current rules of evidence, which sort of guide and in some cases dictate the admissibility of all kinds of different evidence in courts, federal and state. Susan, there are a number of, traditionally Rule 901 has to do with issues of authenticity, and we've already spoken about an opinion of a voice that you referenced has always been admissible. A layperson, a non-expert witness's recognition of a voice, completely admissible in court until now. There's also 901 subpart 2, which talks about non-expert opinions about handwriting. If somebody is familiar with the handwriting, they're able to testify to its genuineness based on their familiarity. But with modern AI, it would not be hard to duplicate somebody's handwriting very well. So what is the state of the rules of evidence with respect to artificial intelligence, and what is the movement to sort of evolve them to keep pace with the changes we're all witnessing?
Thank you for that question. So currently, there have not been any new federal rules of evidence that have actually been adopted and put into effect in response to AI. But the committee that is responsible for thinking about and proposing new rules of evidence has absolutely had many discussions about it, have proposed one actual new rule to address the use of AI in expert work. But I'm going to put that aside because, once again, that's acknowledged AI. And they have discussed, but not actually proposed, a rule regarding authenticity with regards to potential deepfakes. The issue that has been discussed in the committee seems to be, whose burden is it to show that something is a deep fake? Is it under the current rules, right? The person who wants to introduce a video has a pretty low bar in order to show that the video is authentic. They just have to put somebody up to say, yeah, I took that video, it's real. And as long as that person is assumed to tell the truth because they're under oath, that's enough. Or somebody can say, yeah, I took that video from the camera in the store. And again, as long as they're assumed to tell the truth because they're under oath, that is perfectly sufficient. And once that's been established, then it gets shown to the jury. And one of the dangers of deepfakes is that once a deepfake video is shown to the jury, even if the jury is later told that the video is fake, the psychological impact of seeing it in real life often lingers and still influences the way the jury makes their decision, even if they're told it's fake. So it's dangerous for this to be introduced and shown to the jury. The rule that's sort of been kicked around but hasn't actually been proposed yet is an idea that if somebody wants to challenge the authenticity of a video, is that the person doing the challenging has the burden of coming up with enough to show that it could be fake and could have been AI generated. And then the burden moves to the other party to prove that it's real. And that all of this should be decided by a judge and not by a jury, because it's part of the judge keeping their gatekeeping function, strengthening the judge's gatekeeping function, and making sure that the only evidence that gets to the jury and is seen by the jury is actually authentic. Now, this is the conversation that's been kicked around yet, but nothing's actually been adopted because there are many people who think the current rules of evidence are perfectly sufficient. It requires chain of evidence. It requires somebody to swear under oath that this is authentic. As lawyers, we all have rules of ethics, duties under the rules of professional responsibility that we're not supposed to be introducing false things to the court. And as Rabbi Grossman said, the idea of fake or fraudulent problems or unreliable problems have been with us since time immemorial, right? So the problem isn't new. The tech is new. As of right now, there are many people who think the current rules of evidence can deal with the new tech. Some people disagree with that, which is why there's this conversation. And just I'm quickly going to address the question that was from one of the audience members about whether judges are demanding metadata or proof on their own. I have seen judges raise the question and sort of say on their own that they are going to put less reliability on evidence that's been proffered by a party and just a judge only hearing because they have doubt about its authenticity, but they haven't actually demanded to see the background. It would be at that point the party's burden to present it if they wish it. I hope that answered that question.
That's
so
great.
I get clients, who call me, attorneys who call me, kind of just to check out that the client has given them evidence properly, like they're giving them honest evidence. So I do get that nowadays more, where I have attorneys actually kind of saying, we're just calling you because we want to make sure this evidence is real. We want you to look into this before we trust it ourselves. So it's kind of a new thing that we're seeing.
That's good due diligence on their part. David, here's a question for you that we've received from an audience member, which is, it's a technical question. Is AI at the stage at this point that it can positively identify the voice on a recording as the voice of the defendant, or if the defendant kind of disguises the voice? Can it detect that? Can it distinguish between a person on a recording having a cold or sounding different in some way? Has it reached that level of specificity?
There is right now the best tools. If someone's whispering, and we have to define this for a second. You have what's called the known and the unknown. The known is the voice that we record, or that there is an obvious lecture out there that's trusted, speech, whatever. We know that that's the person. That's the known. Then there's the unknown, which is the evidence that comes in, voicemail calls, 911 calls, that kind of thing, recordings in a jail cell, whatever. Like, those are maybe the unknowns. So that's the first thing. If someone's whispering on these unknowns, or someone's yelling or upset, angry, has a cold, those things can affect very much how we can do the comparisons. We really need someone to be speaking either a normal, calm voice, or maybe slightly elevated, but nothing too major. And yes, people who disguise their voices, that will mess up the tests. So there's no way to, but nowadays there's AI tools that we're starting to see that can tell someone's talking in a way that is hiding their identity. But they can tell by the pacing, by the tone. AI is very intelligent, but it's AI. And so the problem with AI tools in general, and this affects probably a lot of people's questions, AI, we don't know how it works. Like, as an expert, we don't know the procedures being used. We don't know the algorithms. It's just amorphous. There's no way to describe it to a court. So we can't yet trust AI because those tools are unknown. We don't know what they're doing to the evidence. We don't know how they're analyzing the evidence. So although we have these new tools out there that are determining this person's not speaking honestly, so far there's no way to really test that to show it's true.
Interesting. Rabbi Grossman?
Yes, so I just wanted to add that as As I mentioned earlier, and as Susan reiterated, many of these questions fundamentally, conceptually, are not new. I just wanted to note the Talmud records a very amusing anecdote that bears on our topic about handwriting analysis. Much of the Talmudic discussion that's relevant to us has to do with verifying signatures. A signature on a document was considered a proof that a witness had signed it and witnessed the incident in question. So the Talmud relates an amusing story where somebody forged a document. He forged witnesses on a document, and then he presented it in court to a certain rabbi, to Rava. He was foolish enough that one of the signatures he had forged belonged to the rabbi to whom he was presenting the document. And Justin mentioned earlier, sometimes fakes can be so persuasive that people are convinced against their own memory that it's real. In this case, though, the judge, Rava, he knew he didn't sign. So he knew this was not his signature. He managed to get the guy to confess that he had forged it. And he asked him, tell me, you did a very good job. I understand that you were able to forge my signature. That's garden variety forgery. But the other rabbi involved, he had some kind of tremors. He had a very distinct, a unique signature. How did you possibly forge his signature? He said, what I did was I stood on a rope bridge, a rickety structure, and that induced artificial tremors in my hand. Or he stood on a kind of a floppy, like one of those bowls, exercise bowls. He stood on a wine sack, so he was trembling when he did it. So a really determined forger can find ways to forge, to produce really convincing fakes before computers, before deepfakes. But the problem of deliberate forgery is being introduced, especially if you don't have a proper chain of custody, once again, is an old one.
That's really great. Susan, there's another question from the audience that maybe you and I, given our criminal backgrounds, can address. The question is there an effort at the state and or federal level to criminalize fraudulent use of deepfakes, whether in court or some other way for financial gain to harm reputations? And the thought is that if there's a sufficient penalty, it would deter that kind of thing. I mean, I would say, Susan, that I think there's ample room right now with statutes as they are to prosecute. I mean, obstruction of justice would certainly be on my mind if a litigant was trying to sort of fabricate evidence, right? And I think the obstruction statutes would be very competent to deal with that. There are also, as you mentioned, ethical rules that lawyers have to abide by very strictly. So I'm not convinced there's a need for new legislation to add to the criminal code, but welcome your thoughts.
I agree with you. And partly it's because I have a philosophical instinct to not want to write rules to try and cover absolutely every situation in existence, because then the rules quickly become out of date, I think. And I agree that there are current criminal statutes, like the obstruction of justice statutes, that would cover, I think, many of the examples that the audience member had put in their question. I also think that there are contempt findings that judges can make and impose on parties if a judge catches a party trying to introduce fake evidence. And then some of the other ways in which people have used deepfakes to cause reputational harm or to harass others, there are criminal laws and probably tort claims, if they want to bring a civil lawsuit, that can be directed towards people who are using deepfakes to cause other kind of harms, like doxing or, publishing a fake video of somebody doing something that, just to use the term revenge porn, right? Like that's out there. And there are laws that cover people who try to do that to others. So I'm not aware of any new criminal statutes that have been proposed, and I actually don't think it's necessary.
Okay.
I think there's an awareness that needs to be made with evidence, because it's not so much laws maybe, but it's just an awareness that these AI tools fake details. These AI tools will take, let's say, an audio that's not so clear and clear it up. Well, how is it doing that? It's actually creating evidence. It's creating fake evidence in doing that. So that's the problem that judges should need to be made aware of, and attorneys too, so that they don't bring this up, they don't just allow it in without really careful scrutiny.
Agreed. If maybe we could pivot slightly to a related topic to deepfakes, but somewhat distinguishable, and that has to do with hallucinations. And hallucinations here is a term of art that relates to the proclivity of AI, at least currently, to fabricate, to come up with things that are completely wrong. And many of the lawyers will know from having heard about these stories or read about them, there are some pretty horrifying instances of lawyers relying upon AI, ChatGPT, what have you, to do legal research, and then using that in briefs, only to find out that the case not only doesn't support the proposition they're using it for, but in some instances that the case doesn't exist at all. It's a complete fabrication, and hence it's referred to as a hallucination. Susan, what can you tell us about sort of the state of play in courts, the perspective of judges on this, orders that have been issued, and just sort of the general thinking about hallucinations and AI?
I remember when this first hit the legal news that somebody had generated a brief. They had used AI, and it included cases that just did not exist. And they were called to task by the judge, and they submitted another response. And I think they did the same thing and cited even other cases that just did not exist. And I could not understand how somebody did not learn their lesson the first time and did not actually check whatever AI tool was giving them, whatever research the AI tool was giving them. In reaction to this, there have been many judges who have sort of generated their own policies and procedures, saying that anybody who appears before them and files any sort of briefing, they need to disclose whether or not they have used AI, generative AI, to conduct any of their research. So from judges mandating that lawyers disclose if they're using AI, to judges actually imposing contempt findings and penalties such as fines on lawyers who insist on using AI and then end up relying on fake cases in their briefs. All that has been what I have seen sort of in the legal landscape these days.
Sure. And it's, on the one hand, it's kind of hard to imagine anybody doing this. On the other hand, there's the reality of very busy law practices, the tantalizing efficiency of AI, right? And lest we think that we're all beyond those kinds of bad mistakes, we obviously all should be, but judges themselves have been caught up in this. There actually have been two federal district judges who had to acknowledge that due to the work of a clerk or a law intern, they actually incorporated hallucinated cases in an opinion or an order. They had to withdraw the opinion and the order. So it's a scary proposition. Let me go to Rabbi Grossman. And Susan, I'll come back to you in just a second.
Thank you. So once again, this is an area where the Jewish law precedent that exists is before modern technology. So it's a question of applying classic principles of Talmudic law, of Jewish law, to the current situation. But here, this is an area where I think the classic Jewish approach is somewhat different from what a modern court would do. We don't really have a robust, a standardized system of sanctions, of authority and frameworks for sanctioning counsel for bad behavior. The main thing that is discussed in rabbinic law is a question of cost shifting, that normally, similar to American law, as I understand it, rabbinic law provides that each party bears his own costs, his court costs, his own legal fees, and so on. But one of the key principles of rabbinic law is that if one party acts in bad faith, then, and kind of like a question of reliance damages, if he acts in bad faith in bringing a suit or bringing a particular motion, and thereby causes the other side to incur costs in detrimental reliance upon his bad faith proceedings, then that the person who acted in bad faith, typically it was the litigant himself. The counsel wasn't really such a big part of Jewish law litigation, but whatever it is, the litigant or his counsel who behaved in bad faith can be assessed the costs that he caused the other party to incur. So that would be the most obvious approach. That in Jewish law we would have that if a lawyer typically behaved recklessly and negligently and wasting everyone's time by submitting, which is essentially bad faith, gross negligence, bad faith, and prolonging litigation and causing the other side to incur costs, he might very well be assessed those costs as similar to any other type of bad faith proceeding.
Susan, did you want to react or follow up?
Well, so I think that one of the dilemmas in this for lawyers, right, is that AI actually can be quite helpful in conducting research, and it can make our jobs easier. We can get things done more quickly. And frankly, there are all sorts of applications out there that are pushing AI tools on us. I'm certain that anyone who uses Westlaw or Lexis these days is like being bombarded with their advertisements about this new tool or that new tool and how it's going to make you better, and everyone's using it. So you better get on top of this and use it as well. And I'm not in the place where I feel like I can say all AI legal research is bad. I can't say that. But I also, given all the examples of hallucinations that have been very public, at least in the legal news, I also can't imagine only relying on something that was generated by AI and not doing a second check of using that as a starting point, but never as your final point.
Yeah, hallucinations, if I can add something about that in regards to video. So we had a client that brought me evidence from the opposing party where they said they had cleaned up this foggy footage of an accident, of a big train car accident. They wanted to see what happened behind the fog, so they had AI clean up the fog. But what AI is doing is just kind of interpreting what it sees to then create something that really didn't happen. In the same way that, hallucinations can happen when you're doing research, it can happen on the video evidence as well. You're muted there, Justin.
Thank you for the reminder. So just to follow up on that, I know that you have been involved in some really interesting cases. One of them at the request of the Minnesota Bureau of Criminal Apprehension to review video footage of an officer-involved shooting.
Yeah.
And there was a lot of protest around that event. And thanks to you and your work, you were able to sort of identify key evidence through that video. Can you tell us a little bit about that and your approach and technique?
Sure. So it was crazy protests for this incident, and they were desperate to have someone independent. So they didn't want to have the police do the investigation for their own shooting, and they didn't even want the state to be the only person doing it. So they brought in someone from outside the state, which was us, to investigate the shooting, and the footage was there was some really clear footage. It was body camera footage, but it was very, very bouncy, very difficult to make out what was happening. So we used our tools, actually frame by frame, to stabilize this footage manually. We didn't want to have anything done automatically by a computer that could then put in pixels that were not really there. So we did everything manually, and we analyzed this. It was like as quickly as possible. Because of the protests, because of the violence going on, because of the disruption to the city, they wanted someone to come through as soon as possible. So like in a couple of days, we did this work, which was like overnight, just constant working on the material. But the thing that I'm glad about is they didn't ask me to fly out and give it over myself. I was kind of nervous about presenting it in person just because of the complete chaos going on. They wanted me to come down to City Hall and just saying, here's what we did. But luckily the police presented it, and they named me, and they presented it to the press, and we could see that the police were totally in the right with what they did, and we proved it with the video. the guy was, the policeman was accused of shooting someone in the back while they're running away. That sounds terrible. I mean, it sounds terrible. And yet, when you watch the footage, when it's been stabilized, we zoomed into it, slow motion, we see the suspect running away and actually pulling out, starting to point something around his side as he's running. And that's only after that moment does the police start shooting. It was a very clean case after that, and it did silence a lot of the issues that were happening in the city, but it was a tense time. It was a tense time for them.
David, for a layperson, a lawyer who doesn't necessarily have your expertise and somebody who's busy, are there some quick tools, tips and tricks that you can share about how to check the authenticity of certain evidence? I've heard about, for example, a reverse image search or reverse image lookup. If you're familiar with that, can they check, metadata, geolocation data? What can you suggest?
That's a hard question because lawyers are really good at reading transcripts. They're really good at analyzing the law, but they're not so technically oriented. At least a lot of them are not. But and there's so many different levels of being technically good. So if you can take a even on a Mac, of a photo. But nowadays, who are sophisticated can fake the metadata to some extent. So the metadata is no longer fully trustworthy. You guys are all mentioning metadata, excuse me. And yes, it can be used if we can identify a good chain of evidence for the materials. But if the materials have lost the chain of evidence, you can't always trust the metadata anymore either. So to say, what do I suggest to attorneys? I mean, I'm not trying to sell myself as an expert, to get business, but you really need to go to someone who knows a little more about the technology.
Fair enough. Let me go back to Rabbi Grossman and pivot here just a little bit and ask you, Rabbi Grossman, if you can talk about generally the acceptability of AI technology as a form of evidence in halacha and Jewish law. And if you can share your thoughts on, I guess, is there a general framework that would apply? Is there something akin to rules of evidence in a Beit Din that would arbitrate and sort of determine whether evidence like AI is admissible or not and can be authenticated or not?
Thank you. So those are certainly very important questions. The question is, do you want the very short answer, the short answer, the longer answer? I'll start in brief. I'm not aware of much discussion of AI in rules of evidence in modern Batei Din. Modern Batei Din, modern rabbinic courts do exist, both in Israel and the U.S. They typically operate outside Israel. They typically operate under state arbitration law, which arbitration law typically gives any type of arbitration panel a tremendous latitude in how to set their own rules and proceedings. In Israel, they have state recognition. There's not as much separation of church and state there. But we actually do a fair amount of civil law. We don't do criminal law, but we actually do a fair amount of civil law, family law, and so on. So these questions are bound to come up. I am not actually aware of much on the specific question of artificial intelligence. But more broadly speaking, the question about rules of evidence and photographic and video evidence in general. So yes, we do have a sophisticated and rich discussion of rules of evidence, and there is discussion about photographic evidence in particular, going back to the early days of photography, basically Civil War era and on. We have discussion of the admissibility of photographic evidence in various Jewish law contexts. I apologize for my screen. It's my computer. I'm sorry. I don't think the lights are going to help, but apologize for the poor quality of the video. So briefly, a little bit about photographic evidence. So photographic evidence, as I said, discussions of it begin in the modern photography basically begins, you can look at the Wikipedia page for the history of photography, basically begins in the 19th century. The latter half of the 19th century and so on is so many of the techniques of modern photography, pre-digital photography develop. And we find the first rabbinic discussions emerge around then in the 1880s or so, 1870s and 1880s, about photographic evidence. Obviously, the photographs were a lot more primitive. They were analog, and they certainly didn't contain metadata. But the basic question arose as to whether photographic evidence was acceptable for various purposes. The primary area of discussion was actually not really civil law. The primary issue was under Jewish law, if a married man disappears, we have to have certain standards of evidence have to be met to presume him dead to allow his wife to remarry. Otherwise, the woman is considered a naguna, a chained woman who can't remarry until we verify the husband's death. The death of the husband was typically established by witnesses who saw him die. They had to A, see his death, and B, they had to recognize who he was and report that it was so-and-so who died. The question began to be, what if we don't have anyone who was there and recognized the person, but we have a photograph of the person produced by the authorities or by bystanders or whatever it was, who can say, this person drowned, and here's a picture of his dead body. And the picture looks to us, the photograph looks to us as if it is the person in whom we are interested. So halakhic authorities of that time began to debate whether that is considered acceptable evidence or not. And there was actually substantial debate about it, but the debate falls into two broad areas. One of which is reliability, especially given the relatively primitive technology at the time. How accurate was a photographic likeness? How probative is the evidence resulting from photographic identification? Whether comparing a photograph of a person to the person that we read, to our recognition of him, comparing two photographs, one to the other, and deciding it was the same person. As I alluded to earlier, much of the discussion revolves around the precedence of handwriting recognition. Halakhic authorities tried to provide precedent in the form of questions about how to verify handwriting. By and large, I think the more dominant view was that kind of the common sense view that to the extent that photographs were considered reliable, they would be admissible as evidence in various contexts. And various contexts is the key, because just as in, let's say, modern American law, the standards of evidence, the standards of proof, the standards of evidence can be very different, whether it's a criminal trial, a civil trial, different types of contexts. So the Jewish law as well has very different standards of evidence depending on the context, whether it's a criminal matter, a civil matter. I could talk more about this, but I'll stop for a moment. I'll stop for breath and give you a chance to give me follow-up questions or point me in a direction that you want to go.
Oh, that's fantastic. David, did you want to react?
Can you give me a question? How about that?
Oh, sure. I thought you were coming off to ask Rabbi Grossman a question.
Oh, no, I didn't.
My mistake. Rabbi Grossman, let me ask you this, just to continue. There are certain kinds of forensic evidence that we have today, obviously, that are relatively modern. There may have been an awareness of different fingerprints, but the ability to compare in ancient times is certainly not what it is today. Dental records, presumably there was a familiarity with different dentition even in ancient times, but again, not the ability to examine and compare in the way that we can today. And DNA, obviously, much, much more recent. How does Jewish law evolve to accommodate these new kinds of evidence?
Yes, that's a great question, and that is something actually that is heavily discussed in the rabbinic literature of the 20th century. As I said, photographs begin in the 19th century. 20th century sees an explosion of literature on the question of the various types of forensic evidence you mentioned. A little bit about dental records, some about fingerprints, and a lot of discussion about forensic tissue analysis. People today, when they hear forensic tissue analysis, they think DNA, because that has basically obsoleted most of the earlier methods of forensic tissue analysis. But the rabbinic discussion, as a legal discussion, actually begins much earlier in the 20th century, the 50s or so, before they had the technology of DNA, where they had simpler, cruder methods of identifying or either ruling in or ruling out identification based on tissue analysis, HLA typing based on markers in the blood, even basic blood typing, OBA blood typing, the different methods of tissue analysis. The details are not so important for us right now, but as the scientific and legal communities began to develop the science and the mathematics and so on to assign probative value to these various types of tissue analysis, so the rabbinic literature begins to grapple with these issues as well. The primary context was, as I mentioned before, aguna. One of the main contexts was aguna for identifying missing men. Another major area, though, was paternity, was child support cases and paternity, where in Israel in particular, where the rabbinic courts handled a lot of civil matters, a lot of family matters, so they had to discuss paternity. And again, the paternity is not the same as identity. You have to determine whether somebody is the father or not. So we have, again, a very rich literature of discussing the value of these various systems. And as a matter of fact, when rabbis, especially in the later half of the 20th century, the latter half began to discuss the halachic probative value of DNA, some of them explicitly referred to dental records and fingerprints as precedents. That was kind of more down to earth, and lay people understood it better, but some rabbis reacted by saying, no one has a problem with fingerprints or with dental records. DNA is more gee whiz technology, but it's just as reliable or more reliable. So why not rely on that? So by and large, I would say that by and large, this is a little bit of an oversimplification, but by and large, the Jewish law approach has kind of paralleled the common sense approach, that to the extent that it is believed reliable, broadly speaking, to the extent that the scientific community has established its reliability, we will generally accept it for Jewish law context as well, with some notable exceptions. So one major exception is criminal law. As I mentioned, we don't really do criminal law today. Rabbinic courts don't practice criminal law. Even in the state of Israel, it's handled by the civil authorities, not by rabbinic courts. But we do have a rich literature of criminal law going back to biblical and Talmudic times. And in some ways, it's similar to American law in that there are very high protections against wrongful convictions. As a matter of fact, the Maimonides has a very famous line where, anticipating Blackstone and other legal scholars, Maimonides says, "Better that 1,000 guilty men shall walk free than that we convict in a criminal context even one innocent man." There's a terrific and absolutely hilarious paper, you should all read it if you haven't, by Professor Alexander Wallach, called N Guilty Men, N like the algebraic symbol N, where he traces from antiquity to the present the value of N. How many guilty men does the law consider it appropriate to go free rather than convict one? So 10 is Blackstone, 1,000 is Maimonides he brings. He actually begins with the discussion of Abraham's argument with God about the fate of Sodom in Genesis. But he traces the value of N in a very humorous and fascinating way throughout legal scholars of all religions, nationalities, and cultures. The point is, the law, obviously, the rules of evidence have to balance the danger of a wrongful conviction, which is typically seen as a much greater problem than letting an innocent man walk free. But when it comes to criminal law, particularly capital law, particularly capital cases in Jewish law, the protections against wrongful convictions are very, very high. As a matter of fact, Maimonides' comment about better that 1,000 guilty men should go free than that we criminally convict one innocent man, he actually wrote that in the context of a categorical exclusion of all circumstantial evidence from capital cases. Unlike modern law that often considers eyewitnesses unreliable and physical evidence, circumstantial evidence, actual forensic evidence more reliable, or maybe both together is the ideal, Jewish law has a very different attitude. Eyewitness testimony is considered the gold standard. Circumstantial evidence, physical evidence is considered helpful, but not on the same level. And Maimonides established a rule based on Talmudic precedents that criminal cases, particularly capital cases, must have witnesses to the crime, and even if the physical evidence is very strong, it will typically not be enough to convict. So various modern authorities, even though we don't actually practice criminal law today, have said that DNA and other types of forensic analysis, as good as it might be, as helpful as it might be in other contexts, civil contexts, allowing women to remarry, determining their husbands are dead, it will typically not be enough in criminal cases, and that is the consensus. There are some views that absolutely airtight, locked room mystery style evidence might be enough in a capital case as well, but again, we don't have real precedence on this because we don't practice criminal justice today.
Thank you, Rabbi. Susan, go ahead. You have a comment first.
So what is interesting about your question to Rabbi Grossman and his response about how rabbinical law has developed in response to advances in forensic science is that it's similar to how the rules of evidence have reacted to advances in forensic science as well. There is a federal rule of evidence on expert testimony that talks about the reliability of the methodology, if the methodology is accepted in the scientific or relevant community, if the person who is conducting the test did it correctly, like appropriately applied the test and the methodology to the facts that were before that expert or the evidence that was before that expert. So there are ways in which our current rules can deal with and have dealt with advances in technology. What is interesting about AI, right, is that for the most part, if you have a DNA analyst on the stand, you can ask that DNA analyst all the steps that person took in order to generate their report and get their result. And there are other people out there who do similar things who can then advise the lawyer or the court as to whether or not this particular DNA analyst did all the steps correctly. But if a DNA analyst or, I don't know, a videographer uses AI in their methodology, at some point there is a gap where the person on the stand can no longer actually explain what that AI application or tool did. And it is essentially a black box that people cannot look into to see what was done. And that is the worry, and that's the danger. And this is a world where somebody is acknowledging, I used an AI tool in order to generate my report. I used an AI tool in order to analyze this DNA sample that has many different people's DNAs in it. And we're trying to figure out what percentage is one person's DNA versus another person's DNA. Very complicated stuff. People have acknowledged that they've started using AI in their analysis of those samples. But if it's proprietary information, if somebody can't fully explain what the AI step had done, can you really test it for reliability?
Susan, it's not only no one can explain it. Like even the creators of the AI can't explain it. You know, they just trained the AI using lots of different data, and the AI figures out the rules on its own. So there's no way to know, at least at this point.
Which is scary.
Yeah, of course. Yeah, it's amazing.
Susan, with that scary prospect, you had started to talk a little bit earlier about some of the benefits of AI and the usefulness of AI in different respects, right? I'm hoping we're far off from the day where a client says, just plug in these facts and tell me what my prospects are, of the client having the ability to do an early case assessment through AI, but we might not be too far off from that. In the meantime, what are some of the benefits that AI does present for more efficient legal practice in your representation of clients that clients can benefit from right now?
So I will confess that I have not adopted any of these tools yet, but I have heard of and looked into. So for example, I've talked with a lawyer who has used AI in order to basically have their support staff generate super basic legal documents. And I mean, standard subpoenas or requests for productions, and to have their support staff, a non-lawyer, use AI to generate the first draft, which then a lawyer will go back and review. And the more basic and sort of uncontested the law or the form is in that area, I actually think AI could probably do a pretty good job of doing a first draft. But the thing is, most legal conflict happens in the areas where the law is not settled. The law is settled. Usually a case doesn't get to trial, or a case doesn't, like, there's a guilty plea or there's a negotiated resolution of some sort or another. It's in the edges where we have litigation, where there's wiggle room for different interpretations of what's really going on with the law. And that is where I think AI is at its weakest. That is where there's a danger of AI hallucinating cases or coming up with an analysis that, like, just gets stuff wrong and is completely unreliable. So I do think that there's an area for AI for the super basic things. There's also there's a world in which AI can help with reviewing large quantities of discovery. So say you have like a camera out there that is recording a week's worth of video. To have an individual person sit there and watch a week's worth of video, that's a lot of hours that you're paying somebody, right? And so is there an AI tool? And I'm pretty sure there is, although I have not tested it out yet, but I have heard of people who have used AI tools to help them review that video. And you can give the tool instructions on jumping to if a particular person shows up, if a particular action is seen, do they ever see a firearm? Are there cars driving through? Things like that. Those are ways in which I think AI can be helpful. And as long as there is a check on the product afterwards, I'm not sure. I think that's a good thing, frankly.
It still has to be really big, to be searching through video like that, okay? Mm-hmm. You have to have really obvious things still. Like, to see if there's a gun or not, it still doesn't work so well because they can have it in their pocket. It could be just ruffling their pants a little bit. And those kind of things still hasn't figured out yet. There's not the tools yet. Although, Susan, I agree, it's going to be there one day. But
by next week, we'll have it.
But yeah, exactly, by next week. But the thing is that what is really helpful is, did someone come in through this door? Every time someone comes in through the door, give me all the videos of someone coming in through this door. And that helps you sort through a whole week of footage. You can really nicely do that. Or in this bottom corner, when a car goes by, tell me. So give me all the footage of a car going by in this corner. Like things like that where it's really big and obvious. It works great right now.
Yeah. Susan, I hear you on not being an early adopter of this. I fully get it. And there are lots of reasons not to. But I wonder if we're at a competitive disadvantage at some point soon if we don't make use of the efficiency in the most ethical, honest way we can. And I'll give you two examples just from this week. We received an audio recording, allegedly of a client. And, you can listen to a recording many times. It's much better to have a transcript of it, right? You can spend time sort of going over the transcript. There are tools now that our firm has accessible where I don't understand it precisely, but you essentially plug in or upload the audio file and it spits out a transcript. Mm-hmm. Now, it's not a flawless transcript. It needs a lot of review, as was just discussed. But wow, what a time saver, as opposed to the old days where you'd have somebody with those foot pedals where they would stop and start the recording while typing. We're well beyond that. On the other hand, I had another encounter also this week with a client who forwarded me an email chain. And the email chain was from opposing counsel to say, we'd like to chat with you, may not be any issues, we'd like to chat, blah, blah, blah. It was months and months and months ago. And I said, why did you not respond to this email? The answer was, well, AI suggested that I didn't really need to. AI and a friend. So that gave me assurance that we have job security at least for another couple of weeks. AI hasn't caught up just yet. Rabbi Grossman, back to you.
So once again, as I've been saying before, and to agree with Susan's point, that many of the fundamental questions that we're asking about AI are really similar questions that have arisen mutatis mutandis with all the different levels of technology. In rabbinic scholarship, for example, throughout the 20th century and even earlier, there have been debates about how much to make use of different tools of modern scholarship, secondary and tertiary reference works, there were kind of conservatives and purists who have said that a true scholar will stick to the primary sources and know everything firsthand and not rely on secondary works as much. And pragmatists have said that, yes, you should look everything up in the primary source, but getting the sources through a secondary source is a great thing. Why spend time flipping pages and just reading through hundreds of pages to find what you're looking for if you can just take a shortcut and use secondary sources. Susan's point, which I've seen made in other industries as well, that relying on AI is a really bad idea, whereas using it to start, or using it as to save some of the boilerplate or drudge work, and then to review and then to build on it. I've seen the same point made among computer programmers, among other white-collar professions, that using them to completely replace people is a bad idea for everyone involved, the people losing their jobs as well as people who are interested in the outcome, whereas simply using them to get started or to find areas of interest to focus on or produce a rough draft that you can work up may very well be a really good idea. I tend to be myself among the pragmatists when it comes to scholarship, that I'll use anything that I actually have not really had any experience with AI, but I typically have no problem with using digital resources, secondary and tertiary reference works. That nowadays you can find hundreds of thousands of volumes of hundreds of thousands of rabbinic works are all on kind of like you have LexisNexis. The lawyers, we have similar things for rabbinic literature spanning thousands of years, all the works, and they have OCR search. So many of the works have not been digitized, but they have programs that do optical character recognition, which again is similar to the problems presented by AI. If you search for a certain term and you get, let's say, negative, it doesn't come up. Like David was saying, that the OCR is not perfect and you may miss things. So if you rely on these technologies to guarantee that you're getting everything worth it, then that's a bad idea. But if you simply use it to find at least a dozen references to what you're looking for, and you know that there might be more, and you go forward with that understanding, that can be a very valuable tool. In my view, at least, it saves time and it leads to better outcomes. So the point is, you have to approach it with an understanding of the limitations. As all of you have said, the problem is obviously worse with AI because of the black box nature of its algorithms. But certainly, if you know what it can do, if you understand its limitations, and you use it as one more tool to build on, certainly a pragmatist like me would say it's a great idea. Now, there are people who, from a religious perspective, do not agree. There are people who believe that since the study of Torah is an act of service and devotion to God, and it should be done in a pure and unaided way, and the more you work, the more of an act of divine worship it is. And that's a view that I respect, although it's not really my view. My view is that we're more outcome oriented to the extent that we can get better outcomes. Again, some people will argue AI is so bad that you'll spend more time cleaning up its work in many contexts and won't save time. That's either yes or no, depending on how well you can use it and where the technology is. But in general, in terms of rabbinic scholarship, I would tend to be of the school that to the extent that you don't rely on it too heavily and you don't assume it can do more than it actually can, it can be a valuable tool in letting you do more than you could do unaided, just like a hammer will let you drive in nails more efficiently than you can do it with your bare hands.
Did either David or Susan want to react? David, I thought you might have want to come on again.
I mean, I can just, in terms of transcripts, we do get transcripts done like that sometimes when it's easy. The problem is there's always these terms of art, words that are not understood by the AI or spelled a whole different word. They also will identify the speaker. So they'll say, speaker 1, 2, and 3. It'll actually identify people based on its understanding of who's talking and who's addressing who, give them names, and they're often mistaken still. But found it to be very useful. But when you're doing searches and then you have mistakes like that, the searches won't come up with appropriate sections that you really want to find. And maybe they haven't been corrected. So AI's, taking a whole bunch of material, let's say from a week, and just making a transcript of it. Well, there's going to be a lot of holes in that. You really need a human being still to go through it and to prepare it, to get it, to find those the needle in the haystack, as they say, that the AI still can't get when the audio is hard to hear, hasn't been processed properly, and you need a human being to go through it.
Yeah.
And I think one of the things that, oh, sorry, go ahead.
No, after you, Susan, please.
Well, one of the things that Rabbi Grossman said, and I think that David was implying as well, is that there's a question of efficiency, right? Like what actually saves us, the human being, more time? Using AI and then dealing with the flawed results that may come from it, or just doing it all yourself in the first place, the way you did it before there was the AI tool. And I think that's what we're all struggling with it. And the calculus may change as AI gets more and more advanced. But I also see another impact of AI, which is things that used to be fairly reliable now all of a sudden aren't. And now we have to expend all of these resources in both challenging and proving reliability of any video, of any photograph. And there's now all these steps, like proving chain of custody, as David has been talking about, takes a long time. You have to bring in a lot of witnesses. It's expensive. And nobody wants that. Nobody wants to make litigation more expensive.
And the chain of evidence,
I just don't know how to deal with that.
And the chain of evidence analysis that you're talking about isn't just in court. It needs to happen way ahead of time, where you're analyzing all the pieces to see, oh, does this look right? Is this the original version? Is this what would have been created by the device they're saying created it? Or does it look different than that? Is there some resolution issue? Or, I'm getting very technical, but it's something that needs to be done months and months and months in advance, rather than just only in court to prove a chain of evidence.
Susan, a point that you made just a moment ago prompts me to kind of think of this as we're drawing to a close here on a macro level, to take a step back, maybe a little bit more philosophically, and just think about the impact of this. There's this concept of the liar's dividend, which people might have heard of, which I think is so interesting. The idea, in essence, is that because of the capacity to fake and to use AI in a manipulative way, it calls almost everything into question, right? And so the liar's dividend is that there's so much that's in doubt, and just by suggesting that it's possible that AI has been used, there's some benefit to the proponent from saying that. So some examples are the January 6th trials, involving all of those defendants who were prosecuted under the prior administration for the events of January 6th. And some of the defendants in that case raised the possibility that AI might have introduced their images in the voluminous video recordings that were taken from social media and used by the prosecution to incriminate those folks. Another widely discussed case is Huang versus Tesla, where Elon Musk said, it's possible that I was deepfaked, and that the comments that you say I made at a certain conference really were misattributed to me because I'm faked so often. I think it's interesting that in both of those instances, it was not enough merely to make the argument. The judges did not accept that without more. They needed some good faith argument on the part of the proponents in order to investigate further. And as a result, those arguments fizzled. But what do you make of the liar's dividend and just sort of the impact of this on our culture and society right now and the legal community that we're in?
So I'm gonna respond in a couple of ways. What you said about how the judges in those particular cases, the January 6th case and the Tesla case, the judges demanded more in order to get to the point where they would seriously grapple with whether or not it was fake, right? And that is what the Rules Committee has proposed in the rule they haven't actually officially proposed, but they've been talking about, is that in order for a lawyer to say that video is fake, in order for them to really get any play out of it, they have to have more than just that video is fake. They have to come up with something, and it could be like there's something fishy in the metadata. like the metadata looks like it's been faked. It could be that, we have this other video of Elon Musk and he looks nothing like this video of Elon Musk. There has to be something more in order for a judge to seriously entertain it and actually hold a hearing, hopefully outside of the hearing, like not in front of the jury, but in front of the judge only. As far as what I make of it, it's okay. I'm getting really philosophical now, but there is this whole concept that we are all losing trust in each other, that nothing we see online is real anymore. Nothing we see on social media is real anymore. We doubt everything unless if it's coming from people who we already trust, which then creates this whole cycle where we only talk to people who we already trust, which means we only talk to people who think like us. And so then we all become more and more like, divided and ostracizing each other. And it's a bad thing. This seems to be more of that. Like we just can't trust anything or anyone anymore, and that's bad. So with that really depressing comment, I don't know how to address it.
Well, I have one thing to say about it, which is clients come to us. We work on all sides of cases depending on who's calling us. We just want the truth of the evidence, but for the most part, we get more defense cases. More either. We do get plaintiff cases in civil. We get plaintiff and defense. But in criminal cases, most of the time, it's defense. And clients are always telling us, the footage has been faked. Now, that's the big thing. They're claiming, like you said, Justin, like, that is the big claim. It's a fake. It's a lie. I'm innocent. Show me why the video is fake. So it's a big call right now. And, often it's not fake. It's just that that's what they hope will be found.
Sure. Rabbi Grossman?
So I mentioned earlier the Maimonides' stirring comments about his version of Blackstone's rule that better that 1,000 guilty men should go free than one innocent person should be convicted. And Maimonides actually goes on and he makes an explicitly slippery slope argument. He's talking about circumstantial evidence in general, and he implicitly or explicitly concedes that some circumstantial evidence is reliable enough, even in criminal context. But he says the reason the Torah completely excludes its use and requires eyewitness testimony is because of the slippery slope, that if one court will accept 100% confident circumstantial evidence, the next court will go down to 99, and eventually you'll be having judges sending people to their deaths based on their whims and their feelings. And therefore, even though on the one hand, all of law, Jewish law, other law, all of law is about making distinctions and deciding what the standard should be and where to draw the line, and we have to draw a line somewhere, at least in capital cases, Maimonides feels the slippery slope is so dangerous, as unfortunate as it might be, as it makes it almost impossible to convict anyone, certainly of a capital crime. It's the price we have to pay. Where the risk of an innocent man getting executed is so high. It's the liar's dividend, I guess. We simply have to completely rule out the possibility of circumstantial evidence. And a similar thing would probably apply, certainly as AI improves, that it'll become so difficult, people will get better at faking the metadata, and the AI will be able to do that too, and so on. It'll become you can never bet against technology doing something. That's a sucker's bet. So as the technology gets better, eventually there may very well be that certainly where the stakes are as high as capital cases, we won't be able to use it. That's the price we have to pay. Civil cases where Maimonides himself agrees the danger is not as high, we are able to set standards, even if they might be not always hard to find, not always easy to find where that line should be, but we set the line somewhere, we do our best. Maimonides himself, though, acknowledges a kind of slippery slope even there. He says that in earlier generations, the law in principle, the Jewish law in principle, allows courts to make decisions based on strong circumstantial evidence, that they're convinced these are the facts without, we don't have juries, so the judges are the ones who make all these decisions. But so the strong circumstantial evidence would be sufficient for a civil case. But he says, unfortunately, as the system, as the system sank in integrity and competence, you had courts who weren't so effective, so we had a sea change in policy. We no longer give judges that power. We can't trust judges outside of more hard and concrete evidence. We can't trust them to make findings of facts on their own without more precisely specified evidence. So again, it's kind of a slippery slope problem. Ideally, we'd say, let the judges who are good and know what they're doing do it, and not those who aren't, but you can't always do that. So I don't have a solution, and it is depressing, as Susan was saying, to not be able to trust anything. But again, depending on what the stakes are, then we decide where to draw that line and how much we have to just throw out totally in order to where our priorities are. But yeah, I don't have a solution either, and it can be depressing, but that is the world we live in.
You're muted, Justin.
Gosh, all this time after COVID, and I'm still not unmuting myself. Rabbi Grossman, there's a quote from the Torah, Midvar sheker tirchak. It's an injunction to remove oneself, to distance oneself from falsehood, right? What application does that have here in your view, in terms of, I guess it gets to the core issue of trying to identify the truth and the role of judges in Jewish law in divining the truth. But more generally, do you have any thoughts on midvar sheker tirchak and that injunction to distance oneself from falsehood in this context?
Yes, so midvar sheker tirchak, distancing yourself from falsehood, actually appears in the Torah in the context of other rules that govern the litigation, that govern the judicial process. Many commentaries say that its primary impact, even though it's certainly an ideal we should aspire to in general, many commentaries say that the primary thrust of the admonition is to judges and to people acting in the context of litigation. And the Talmud actually makes it clear, and as you alluded to by saying it says tirchak, you should avoid, rather than don't lie, thou shalt not lie, that tirchak means distance yourself, meaning even things that are not technically lying. The Talmud has a whole laundry list of various types of shady practices in litigation where even if you aren't lying and even if it's in the service of a legitimate goal, he actually does owe you the money, but you have to kind of tell some white lies to the court, or you have to kind of manipulate the process to get the ends don't justify the means, to keep far away from falsehood. That the Torah is very, very strict about this. There's a responsum of Rabbi Shlomo Solomon ibn Aderet, a leading 13th, 14th century decisior, who was asked about someone didn't have the proper evidence to win his case in court. I mean, the facts were on his side, but he couldn't prove it in court, and he asked about whether he could lie or misrepresent something, a document in court, in order to win. And he reacted with horror. He said, Chas v'shalom, heaven forfend that a Jewish person would do such a thing. Absolutely not. The ends don't justify the means. And he says, truth is beloved, the falsehood is hated, and there's nothing like truth, and we always have to stick to the truth. Like most things, it's not that simple. There are some cases where we can justify some type of white lie, but in general, the Torah does have very, very strong views on the importance of telling the truth, particularly in the judicial context. So I think we would all agree that deepfakes in the most sensational, egregious way are clearly out of bounds, unacceptable on a variety of grounds: fraud and lying and stealing, and if you're using it in a civil case. The question is more the more interesting and more gray areas are the questions that Susan had in some of her slides about the cases of using AI to, or like David was saying, using AI to improve quote unquote video. Even the pre-AI methods introduced pitfalls that weren't there. Your nearest neighbor and whatever the techniques are, upscaling resolutions, but there at least it's not a black box. There at least someone can trace your steps and reproduce what you've done. AI has the black box thing. You may be making up stuff. So midvar sheker tirchak is clearly a very strong imperative in making sure that we get the truth and nothing but the truth. Again, exactly where to draw the line is it's difficult to translate something as aspirational and as broad as that into a specific rule about AI. But clearly, I would fully agree that that should be a signpost to us about how we should behave.
Fantastic. Let's fast forward. It's hard with the pace of technology, as I said before, to think about what's even a week ahead from us. But I'd love to get thoughts from the panel, from each of you, on your perspective of how this world will look 5 years from now, from the perspective of AI. What will we be struggling with then? What will we be able to do? What challenges do you hope or think we might have overcome by that point?
So I picture AI. I know that AI is being trained right now to predict future actions by people. based on their profile. So they like their proclivity to do a crime ahead of time, based on their actions, based on their posts. So that's a scary thing for me to think about, is using AI to analyze someone's personality and their life based on everything the government knows about them. Say, this is a risky person. This person's risky. We need to keep an eye on them more carefully. So that's one thing. The other thing that's a little more direct, and you said, so you're saying predict like way off in the distance, many years. I'm thinking like a year from now, right now, in terms of now video. It's fascinating that AI can be used to predict the next section of a video. It wasn't recorded, but it's saying, based on the actions that we see in this video right now, what's the person going to do? What's the car going to do the next minute later? So AI's, because of all the amazing recordings, I mean, literally Tesla has like 7.5 billion hours, I think, of videos that it's collected. And it's not just cars, but it's people walking in the street and car accidents and people interacting. So all this collection can be used to say, okay, we have surveillance video. The AI can now invent something that happens 5 seconds later or a minute later. And we might not be able to tell a difference at all. Like, we can't tell because it has the existing footage. It's just adding to it now. And I think that's a big concern, that corporations might do that, to get out of something, honestly, to save maybe hundreds of millions of dollars. They might create something like that and give it over as evidence, and we won't be able to tell.
Or just to add on, insurance companies potentially dumping an individual's life stats. I mean, not too different to the way actuaries do right now, but at a much more refined, precise way, making predictions about longevity and health and so on.
Yeah.
Interesting. Susan, Rabbi Grossman, thoughts about the future?
So can I answer that in two parts?
Please.
The first part is partly in response to something that an audience member asked about whether or not, lawyers may become obsolete in certain areas, like basic areas of the law, like leases. And I will say that, sometimes lawyers just aren't necessary, and really we shouldn't be paid as much as we're paid to do certain things. Basic leases are sort of out there already online. Doing a divorce, if it's uncontested and like nobody's trying to get property from the other person, very basic. I don't think that paying for a lawyer is necessary, and it makes things inaccessible to people because of the cost. And I am okay if AI sort of reduces the role of lawyers in certain areas where, frankly, we just shouldn't get paid that much to do it anyway. I am secure that lawyers will always have a job because there will always be the complicated cases. There will always be like the world and the edges where law just hasn't really dealt with yet, because you can't write a set of rules that's going to deal with every single situation. It is just impossible. So I feel job security, while at the same time, I am hoping that, certain things just become less costly for folks in the world to do. The second part,
I applaud you, Susan. That's amazing that you say that as an attorney. I was so happy to hear that.
So the second part that I want to talk about, and David touched upon, is this idea of like predicting recidivism. There are courts, there are systems out there that have tried to do that. And what they found is, and I think there was a ProPublica article about this at some point in time, is that they were racially biased. Like the people who were predicted to be like low recidivism risk tended to be white. The people who were predicted to be high recidivism risk tended to be Black. There was like all sorts of ways to go about like trying to figure out why. But the bottom line is that the results were racially skewed. And if people followed those results, they would just be increasing that bias. They would be exacerbating it. And so the idea that we would rely on AI to predict the future when we have no idea, or there may be garbage going in to the AI in the first place in order to do the prediction algorithm, that what is going in to the AI to do that predictive algorithm includes all the flaws of our current society, where we judge people based on like the amount of resources they have or what they look like and things like that. That's a horrifying thought to me. And I would hope that we have guardrails against that.
Susan, it's really interesting you say that, because something we haven't touched on at all, and probably could be an entire different webinar, is anti-Semitism and AI. There have been some interesting studies and reports about the prevalence of anti-Semitic, anti-Jewish, anti-Israel bias in certain AI platforms. So to be continued, that's a whole other can of worms. But Rabbi Grossman, what about you?
In terms of predictions, a wise man once said, it was either Niels Bohr, Yogi Berra, or a variety of other candidates. He said, making predictions is difficult, particularly about the future. And given that technology, the rate, the logarithmic rate at which it's been progressing, all bets are off where we'll be in 1 year, 5 years, 10 years. I'm as scared as anyone else, optimistic as some people are, but really very hard to know. I do find it's a serious fallacy when people often say, clearly AI can't do what people say it does, and therefore it's worthless. Well, now it can't, but the rate at which technology, particularly computer technology, advances, it's pretty scary to know where it's going to end up. In terms of what our stance should be, let's say a more practical question, what our stance should be about approving of the development of the technology, insisting on guardrails, opposing the technology. Again, as I've been saying all day today, a lot of these questions are not fundamentally new. So in Europe, it was the Luddite movement of the 19th century that opposed technology. In that case, it was mechanical technology. It was mills and automation because of jobs. It was the robots are coming for our jobs. The machines were coming for their jobs, and they opposed it because of the social disruption that it entailed. I often point out we have an interesting, Judaism was not heavily involved in that, but Judaism did engage that question as well, religious Judaism, in an interesting context. There was a matzah. We eat the matzah on Passover for thousands of years. It was made by hand. In the 19th century, they developed machine matzah, which is quite common today. Most matzah today probably is machine-made matzah. Some people still get hand matzah, but machine matzah became developed in the 19th century. Before they had electricity, mechanical machines were making matzah. So there was a tremendous debate in religious circles as to whether machine matzah was acceptable. A lot of the debate was based on technical ritual questions and religious questions and religious conservatism, but there was an economic aspect to the argument as well. One of the leading opponents of machine matzah, Shlomo Kluger, great rabbi of that time, one, or perhaps his primary objection to machine matzah was that it was taking away jobs. It was taking away jobs from the poor who really needed that income. Passover is expensive enough as it is, and they really needed the income, and he felt it wasn't fair. Others disagreed. Other equally eminent authorities disagreed, and they said, in one particularly sarcastic rejoinder to him, Rabbi Yosef Shaul Nathanson, a great Galician rabbi, responded. He said, very sarcastically, he says, I don't want to accuse you of hypocrisy, but when you printed your many works, did you write them by hand, or perhaps you were guilty of using these newfangled mechanical inventions of the printing press? Who knows how many copyists you put out of business by doing that? So technology moves on, but it doesn't mean we have to blindly accept it. We have to figure out what's a good idea and what's a bad idea. Clockwork Orange style problems of predicting that David was saying about predicting the future is even more scary. To some extent, that we can solve that from the legal perspective of disallowing. We have to identify that, but we can obviously disallow anything we know is a speculation of the future. But the question is, people are going to present it as video of the past rather than of the future. That creates the real problems of that's yet another form of deep fakes that we've been discussing tonight. What to do about ruling out all kinds of faked video, whether deliberately faked, whether overeager, overenthusiastic technologies that are interpolating or adding stuff. Personally, when I worry about AI, it's more not what we've been discussing today, generative AI and large language models and so on. What I worry more about is what they call AGI, the artificial general intelligence that can actually behave much as people do and think and do the kind of things that people do. I have kind of existential worries about what that means for us. As a religious person, we talk about the soul. We try to understand what the soul is. Will machines have souls? Do androids dream of electric sheep and so on? But the question is, will computers be sentient? What does it mean to be sentient? And these are the really weighty, deep questions that I worry about, and not so much the pragmatic ones. But yeah, these are all worries, and people who are far smarter than I worry about them too. I don't have that much insight other than I share everyone's worries and everyone's concerns about where we're going, but also some optimism.
Fascinating. Well, on that note, let me just suggest in closing, there are things to be worried about and cautious of, but I think in addition to the liar's dividend, there may also be a truth dividend. And that is that by having greater awareness for these issues, we can sort of all learn and adapt in light of these developments, hopefully contributing to a world that's full of more truth and falsehood, and prepares us better to sift out the fact and the fiction.